Hi everyone, and thank you for joining us on our webinar today. I'm Tony and I'm Wired's Marketing Manager. We'll start off this session with a little bit more information about Wired Plus in case you haven't dealt with us before. Now, we're a full service email marketing agency specialising in email marketing and marketing automation. Our clients range from small businesses to large PLCs and everything in between. We offer managed services through an agency style setup for clients who want to outsource their email marketing strategies, as well as offering support and training to clients who would prefer to create email templates and campaigns before sending them themselves. Whether you're looking for a bespoke template, do-it-yourself email sends, or full campaign strategy and implementation, we can support you to success. Now, my own experience spans over 20 years, during which time I've been involved with digital marketing projects, ranging from small, highly targeted postcode-specific campaigns to full national and multinational integrated marketing strategies. I've worked across a number of B2B and B2C sectors and love sharing what I've learned through that time. I was also voted as a top 5 influencer by the Google Squared program. So that's what you need to know about us. We'll now move on to the webinar. Now, we always have a broad range of attendees at our webinars. The purpose of this one is to guide you through why GDPR is important to marketers such as yourselves. Now, do need to make it clear that we're not providing legal advice, and you should seek support from an internal or external legal advisor if you do wish to take any actions regarding GDPR and compliance. Now, the webinar should run for about 30 minutes, and you can contact me directly after we finish if you have any questions or if you want to have more of an in-depth conversation. Please feel free to ask any questions that you might have at any time. You can use the control panel on the right-hand side of the screen. So in recent months, we've received many calls concerning the impact that GDPR will have on businesses within and outside the EU, with questions surrounding whether GDPR might change how businesses are collecting, managing and using data. So we'll explore the similarities with the existing 1998 UK Data Protection Act and highlight the changes and new requirements, allowing you to ensure that your business's practices meet the new regulations and hopefully avoid the penalties. So through the webinar, we'll talk through what we know about GDPR and answer all the questions that you might have surrounding the effects that it may have on your current practices. The purpose of the webinar is to provide a deeper insight into GDPR from simply the words to the suspected changes that you may have to make as well. So without further ado, what is GDPR? So this is what we'll be covering. What is GDPR? How does GDPR impact you? What you need to know about personal data, sensitive personal data requirements, changes to individual consent, enhanced child personal data protection, how does GDPR affect marketers, bringing your existing data up to GDPR standards, compliance support, breaking the rules, the legislation, and the most common frequently asked questions. So what is GDPR? Well, the Data Protection Directive guarantees an effective protection of the fundamental right to data protection. The trust and confidence of individuals and the competitiveness of the EU economy has created the need to refresh and modernise the current regulations that were in place, as they were created at a time when online services and the current data challenges of data protection didn't even exist. With social networking sites, cloud computing, location-based services and smart cards, processing of personal data has grown exponentially over the past 10 years. We now need a new clear set of rules to make sure that people's right to personal data protection are being upheld and that they remain effective in the new digital age. Not only will this be beneficial for the public, but also the development of the digital economy as well. Now, the EU's GDPR is actually the result of 4 years of work by the EU to bring data protection legislation up to a higher standard with new, more detailed policies. In theory, is a harmonisation of data protection acts from across the EU community. So currently the UK relies on the DPA 1998 or Data Protection Act 98, which was actually enacted following the 1995 EU Data Protection Directive, so it will be superseded by the new legislation. GDPR introduces higher and more forceful penalties for non-compliance and breaches, along with a number of other changes. Obviously, looking at the timescale since the EU directive in 95 and the Data Protection Act in 1998, you can see why there's been a requirement for these changes and to update the data protection practices. So we have received questions surrounding the government's confirmed decision to leave the EU, as we call it Brexit, but it has been confirmed that this will not affect the implementation of the new GDPR regulation. It does mean that ultimately there may be some slight changes as we go forward once the agreements are made, but for now there's not going to be potentially any changes. So how does GDPR impact your organisation? Well, as many businesses and service providers work alongside the digital economy, it's crucial for them to remain at the centre of compliance, obviously working with the government to uphold privacy and protection laws that ensure the safeguarding of the public. If you work in relation to the current Data Protection Acts that are in place, it's highly likely that you'll also be subject to new general data protection regulations. Similar to the DPA, GDPR applies to both personal data and sensitive personal data, and the principles remain the same, but they now have some additional details and responsibilities. GDPR will affect all businesses that use personal data from EU citizens, so it doesn't matter whether you're based in the EU or not as a business. If you're dealing with EU citizens' data, it does apply to you. So if you collect email addresses and personal public details, then send emails to those contacts, you'll have to comply with the new GDPR no matter the location of your company. So what you need to know about personal data. So as I've previously mentioned, the personal data requirements are relatively similar to those found in the 1998 DPA. However, in the new GDPR specifications, the information and definition of personal data has become more detailed, and it makes it apparent that even IP addresses can be seen as personal data. Now, the expanded definition of personal data provides a large range of personal identifiers that form personal data. It explores the related changes in technology and how organisations collect and collate the public information that they gather. If you're working with customer lists, contact details, holding HR records, for example, the alteration in definition might not make a huge impact on your day-to-day working. And if you already comply with the current Data Protection Act regs, you'll be aware of most of the requirements which will remain current in GDPR as well. So both manually input data and automated personal data both have a wider definition in the new GDPR. Within the regs, you may be required to chronologically order manual data sets that contain personal data. Simply being unidentified by a name doesn't mean that data is not personal. Even the removal of potentially identifying tags from a data set may not make the data anonymous. With the advancing technology of re-identification attacks, they become much more effective, and they're known already to work on search engine records. This is something they're trying to steer away from. It's suggested that the term anonymous data should be specifically defined. It would also seem that the proposed regulation wouldn't encompass data that can't be linked to a natural person. However, if the term's not adequately defined, it may lead to flaws, which allows loopholes that could be used by data controllers to circumvent the proposed regulations. The element of identifiability by third parties also has a wide definition. That's intentional, so if the controller of the data is unable to identify a person, the situation where they may disclose data to a third party is also encompassed by that regulation. So sensitive personal data requirements. Now this is referred to by the GDPR as special categories of personal data. Categorization is similar to the rules of Data Protection Act, but with a few small changes. With GDPR, when you're processing genetic and biometric data, if that's something you do, to specifically identify an individual, then this will be included in the special categories. The GDPR includes a new accountability requirement and additional details, but the principles are generally those of the Data Protection Act, although it doesn't include guidelines on the rights of individuals or refer to personal data when being transferred overseas, since these are covered in other articles. With GDPR, there's an additional principle of compliance, and that best practice will be to document decisions taken regarding the processing of data. It's another big thing under the General Data Protection Regulations, that if you're processing data or collecting consent for data, the data use, that there is documented evidence that you've actually gone through those processing, why you've been processing that data. So changes to individual consent. Although it doesn't clarify the difference, GDPR refers to both consent and explicit consent. It also states that both types of consent should be given as a clear intention of the individual's wishes and given freely in a specific and informed manner. So consent is defined as a freely given, specific, informed and explicit indication of wishes, either by statement or by clear affirmative action. According to the proposal, it shan't be a legal basis for data processing if there is a significant imbalance between the controller and the data subject. It's incumbent on the controller to prove that consent has been given, going back to the documentation piece. A record must be kept of how consent was made, as GDPR states it must be verifiable. Silence or no response doesn't mean effective consent, and any time the individual can withdraw their consent. Where it's in a third party's legitimate interests or the needs of your own organisation, then you can rely on alternative legal bases for consent to be valid. These are under the different grounds for processing. There's two really that apply to marketing. You've got consent, obviously, which we've just discussed. You've also got legitimate interests, and then you've also got performance under a contract or performance under pre-contract negotiation. So when reliance is placed on consent already given under the Data Protection Act or the EC Data Protection Directive, you'll need to review the process for valid consent to ensure compliance with GDPR. So in theory, even if you've got consent from 95, 98, you need to go back and ensure that that is documented and verifiable and compliant under GDPR now. You can't assume that just because they gave consent 20 years ago that it still stands now. Now, if compliance isn't met, then fresh consent needs to be obtained, or you shouldn't process the data, and you'll need to cease processing data for which you don't have valid consent, if that's one of the grounds that you're wanting to use. In the Commission's proposal, legitimate interest pursued by a controller is one of the 6 grounds for lawfulness of processing. The 5 others are consent, necessity for fulfilment of contract, legal obligation, necessary for vital interests of the data subject, and necessity for performance of a task in the public interest or official authority. When the subject of the data is a child, then the fundamental rights and interests will override any legitimate interest that the controller may have. The regulation also sets out the principle of compatible purposes, an extension of the basic concept of data protection, that personal data must be collected for a specific purpose only and not undergo further processing for any incompatible purpose. There are certain circumstances where the proposal allows exception to this rule. For example, when the controller is simply processing data as part of a data retention to comply with the legal obligations. It can't be for their perceived legitimate interest. There are claims that the exception should include legitimate interest of a third party as well, but this would undermine the effect of the limitation, since a reasonable person might expect that the data was only being collected for a specified and specific purpose. So enhanced child personal data protection. To increase the protection of children's personal data under the new provisions of GDPR, you need to ensure that your privacy notice is written in simple and clear terms that a child would comprehend, especially when offering services directly to children. You'll need to obtain consent from a parent or guardian to process a child's data when targeting online services at children, categorised as an information society services under GDPR. Parental or guardian consent for access to online services is required for children under age 16, although member states may legally set this at age 13 and under. That's something that the Information Commissioner's Office, the ICO, who are policing the GDPR in the UK, are looking to work towards. Internet services provided on a chargeable basis and at the user's request will come under the category of Information Society Services under GDPR. When the processing is in relation to counselling or preventative services being directly offered to a child, then parental or guardian consent isn't required. Where children's personal information is used for the purposes of marketing and creating online profiles, then GDPR places emphasis on the significance of protection. So the right to erasure or right to be forgotten. There was a case brought against Google Spain by Spaniard Mario Costella Gonzalez, and that confirmed the principles of the GDPR, which means consumers will have the right to be forgotten or erased from the databases of companies holding the personal data, provided there are no legitimate grounds for retaining it. So unfortunately, your mortgage company would have legitimate grounds for keeping your data on their database. The right to be aware of when your data is hacked is also a crucial part of GDPR. Businesses and organisations are required to notify the National Supervisory Authority of serious data breaches immediately, ensuring users are then able to take appropriate measures. So as I mentioned, in the case of the UK, that would be the ICO, or Information Commissioner's Office. Now this right has two aspects. The first is that the subject of the data has the right to have the data deleted when the controller has no further reason to process the data or is in breach of the regulation. The exceptions to this are when it's necessary for the rights of freedom of expression or if it's to meet the legal obligations of the controller for data retention purposes. The second is that when deletion is requested and controllers have made personal data public, they must take all reasonable measures to inform third parties who are processing the subject's data in publications for which the controller is responsible. In an online environment, this measure should contribute to meaningful erasure. It's expected that there will be certain exceptions, such as when data is maintained for proof. In this instance, there will be restrictions on the processing. Also, where records are held in the public interest, such as for public health, for legal obligations, and for research. Strengthening the right to be forgotten is to help people better manage data protection risks online. So if individuals no longer want the data to be processed, and when they feel that there are no legitimate grounds for retaining it, the data will be completely deleted. This is to empower people's rights, not to erase history or to restrict the press. There are provisions that could increase consumers' rights over the data, but these also create questions about how they'll apply in practice. For example, the right to be forgotten is being extended beyond web searches to all areas of online data and profiling. So someone could ask Facebook, Twitter, Snapchat, or another social network to delete the profile entirely. So the OneStop Shop. Now each business will be answerable to just one single data protection authority. Therefore, there'll be better cooperation between data protection authorities on cases with a wider European impact. Not only that, but the regulatory environment will be simplified by doing away with unnecessary formalities. The one-stop shop will streamline cooperation between the data protection authorities on issues with implications for all of Europe. So companies will only have to deal with one authority, not 28. It will ensure legal certainty for businesses. Businesses will also profit from faster decisions from one single management and will receive consistency of decisions where the same processing activity takes place. So how does GDPR affect marketers? Well, in the UK, importance will be placed upon the way that the ICO interpret and apply the law. What is understood at present is that any attempt to identify individuals by appending extra information to pseudonymous data won't be allowed unless the individual has given consent. So while under the EU Privacy Directive, marketers are only allowed to send emails to people who've opted in to receive messages. GDPR specifies the nature of consent required for commercial communication. To be compliant with GDPR, brands should collect affirmative consent that is freely given, specific, informed and unambiguous, with effect from May 2018. But it's good practice to get that done now, because if you've not got consent after May 2018, you can't use those contacts. GDPR also requires that the sign-up process must inform subscribers about the purpose of collecting personal data and the brand that is collecting the consent. That also includes the double opt-in verifications when email addresses are collected and used. Under GDPR, some methods previously used by marketers to grow the database will no longer be compliant. So, for example, someone leaving their email address when they're downloading something must be made aware that you will use that personal information to send marketing messages. It'll be illegal to add those email addresses to your mailing list if they don't agree to the use of personal data for marketing. So how will data protection reform encourage innovation and the use of big data? So according to some estimates, the value of European citizens' personal data could grow to nearly €1 trillion annually by 2020. It's not far off now. The new EU rules will offer flexibility to businesses, all while protecting individuals' fundamental rights. Data protection by design and by default will become an essential principle within the GDPR policies. It will incentivise businesses to innovate and develop new ideas, methods and technologies for security and protection of personal data. Businesses will have incentives to use techniques such as anonymisation, or removing personally identifiable information, pseudonymisation, replacing personally identifiable material with artificial identifiers, and encryption, encoding messages so only those authorised can read it, to all of those to protect personal data. So bringing your existing data up to GDPR standards. GDPR applies to all existing data as well as new subscribers. So data needs to be stored so you can provide sufficient evidence of consent for your contacts under GDPR standards. Lack of evidence might preclude you from sending further emails to these subscribers. So marketers need to review their email processes when dealing with EU citizens, and they have in theory two main options. For subscribers coming from different parts of the world, set up a separate sign-up process. This would involve people coming from the EU going through a GDPR compliant sign-up process, whilst in respect of, say, prospects from Australia, things would remain the same. A significant drawback to this approach would be the related costs and complexity of running two separate sets of lists. The second option is to ensure that your database is up to GDPR standards. While adapting opt-in processes to meet EU requirements might slow list growth, in the short term, it would be outweighed by the benefits to marketers in the improvement of your list quality and ensuring that emails only go to subscribers who actually only want to hear from you. It will be important to undertake regular reviews of data to eliminate the risk of sanctions, allow action to be taken regarding any issues, and remove the need for a full data cleanse. It may also be useful to obtain advice on the use of data and improvements to data protocol from qualified third parties. At times it may be necessary to contact consumers to update opt-in consent levels and ensure compliance. This could also be used as an opportunity to improve market knowledge, find out more about the consumer, maybe make further direct offers to them. So compliance support. To ensure compliance with GDPR, it's advisable to seek support from an established reliable source, as many brands fail to understand its complexity for their business. A compliance heritage asks detailed questions about the forthcoming regulations and is a real necessity, so make sure you source the right one. This shouldn't be rushed, as software changes might be necessary to ensure the correct changes to data protocol and to allow data audits, since there's usually not a storage facility for keeping consent forms within CRM software systems. So breaking the rules. For companies that don't stick to the rules, there are heavy penalties, and non-compliance can lead to fines of as much as €20 million or 4% of your annual global turnover, whichever's the greater. It's uncertain how heavy the fines will be in reality, and significant reliance will be placed on consumers to report breaches when they occur. It's likely that the authorities, in our case the ICO, will focus attention on the most serious violations of GDPR. The legislation will apply to any company that handles EU citizens' data, even if that company is not based in Europe. So the GDPR will introduce significant changes following these concepts. So transparency and consent. Permissions must be given for the use of information provided, and individuals must consent to the sharing of the personal data. GDPR requires for consent to be unambiguous, not to be assumed from inaction. This will mean that many data protection notices will need to be amended. Children and consent. Online services which rely on consent to processing will now need verifiable parental consent for the use of a child's personal data. Member states are free to set their own rules for those aged 13 to 15 inclusive. If they choose not to, parental consent is required for children under 16. Regulated data. The definitions of personal data and sensitive data have been expanded. For instance, the latter now includes genetic and biometric data, as I mentioned previously. So pseudonymization. Now this is a privacy enhancing technique where information that allows data to be attributed to a specific person is held separately and subject to technical and organizational measures to ensure non-attribution. Personal data breach. Now this is a new security breach communication law that will be introduced for all data controllers regardless of the sector. Data protection by design and accountability. So organisations are required to adopt significant new technical and organisational measures to demonstrate the GDPR compliance, and they can be subject to investigation and display of evidence at any given time. And enhanced rights. So data subjects are given substantial rights, including the right to be forgotten, data portability rights, and the right to object to automated decision making. And supervisory authorities. So regulatory oversight of data protection will change significantly, including via the introduction of a new lead authority for certain organisations. So the legislation, if you do want to find out more about GDPR, you may find the information you require within this GDPR comparison PDF. The document provides a breakdown of the current draft of GDPR, while also evidencing the difference between old and new policies. If you're a large organisation that may be affected by GDPR, this may be a document that you'd forward on to your legal department if they're not already up to speed on it. So conclusion, that's the end of the webinar. I hope that you found it helpful, that you now have a clearer understanding of the up and coming changes which may be implemented from the new GDPR legislation. And again, I just want to mention for those who may have missed at the beginning of the webinar, the information provided isn't legal advice, and you should seek support from an internal or external legal advisor if you do want to take actions regarding GDPR. Now, our contact details are on screen. At Wired Plus, we're very open to any questions that you might have. Please feel free to contact us if you want to see how Wired Plus can help you achieve email marketing success, or if you have any questions about today's webinar, or even if you just want to have a chat about what you're doing with your campaigns at the moment. So thank you very much for joining me today. Finally, Wired Plus and I would like to thank you for attending our webinar, and we wish you every success with your email marketing in the future.